kujjukira kubanga yali musajja mugumu naye kati mulimu nga Kavuma yaliko omulamuzi akulira abalamuzi saabalamuzi kakati Kavuma ng'afa ng'era tukuŋŋaana nga tugaa tujjukira Kavuma abantu bayinza okuwooza nti tuli balalu so abalamuzi nga mukyalina ekiseera mwenna abali mu judiciary muyigire ku bakanyehamba ba Athawode Bakino Mujuni eggwanga muliweereze kuba obulamu bwe muyina faana abantu abala bugere teke kujjukirako bibinga bye tujjukira ku Kavuma Sekaana n'abalala ennaku ezo mwalaba Comfort eyali mu musango gwa Besigye n'agaa nti ebisaanyizo byonna ebyokufuna beero Besigye obiyina naye tetugenda gikuwa kati eyo Comfort bwafa ng'era tujjukira nti omulamuzi afudde so abalamuzi mutuyambe tujjukire ebikolwa ebirungi netafayiri mutadde ku Uganda abantu baleke kukaaba nga bakaaba nkaaba ya bulimba so twebaza Kanyeranga obuweereza bwe era tujja musaalirwa naye nga twali tukimanyi bulungi nti bwekituuka emyaka egyo egy'okuwummula osobola okuwummulira ku nsi naye ne wabeera n'okuwummula okusembayo. Thank you very much.
The international community mourning one of the luminaries of constitutional law and governance in this country. In the legal profession we have people who have exceedingly surpassed the test of an ordinary lawyer or justice or judge, and in the league of their own. Those ones are called jurists. Kanyehamba has been one of the known jurists beyond the borders of Uganda. And we do celebrate him. And amongst jurists, they are also sages. Yes, sages of the law. Abrogating the constitution, we drag him to court. Indeed, he stood by his position and took Museveni to court, to the constitutional court. And he argued out the case from a wheelchair. That is Kanyehamba. In a special way, by his position, his firm stance in the 2006 case. That is Dr. Besigye versus Yoweri Kaguta Museveni, election petition number 1 of 2006, which was argued out in the Supreme Court. I was still a very young man at that time. I was one of the lawyers in that case. Supreme Court election petition number 1 of 2006. Dr. Besigye versus Yoweri Kaguta Museveni and the Electoral Commission. Kanyehamba was very instrumental, very instrumental, very assertive, and he took a decision which was unprecedented at that time to annul Museveni's election and direct there should be a fresh election. Never mind the history they had shared, the journey they had traveled together with Museveni. He took a firm position and said, no way. Museveni rigged the elections and elections must be nullified. That wouldn't be the issue because he was not alone. It was a 4-7-3 judgment. There were 4 in favor of upholding the election and 3 who dissented, who were against the majority decision. The 4 were Odoki, Murenga, Katrebe, and Karokwa. The 3, Kanyehamba, Sekoko, and Justice Ode. Those were the 3 who dissented. But what makes Kanyehamba a unique character who stands out amongst the many is his maverick character as a judge. You know what he did in that case? He told the behind the unforeseen events that led to the reversal of the earlier decision, which was in favor of an early election. He told the story, the untold story. He told it. He said, upon conclusion of the hearing of the case, judges normally go into what they call a judges' conference to decide which position they are taking. He tells us, and this is well documented, go and read The Blessings and Joy of Being Who You Are, written by Justice Kanyeham. And on several occasions he has told this story. The intimidation, the what, and I think the last spanner in the wheel, according to Kanyehamba, then Odoki calls the conference and tells all the judges that yes, he respects the decision they are taken, but he had talked to the president and the army. They said they will not accept that decision. So are you ready for the consequences? That's what Odoki asked. Are you ready for the consequences? You deliver the decision, the rest is your business. Then one of them dropped the position he had taken. Now it goes back to 4 against 3. One of them again returned to the other side. So the final position now comes, the final straw came late in the night, again, when they were going to take a decision. That's when Mulenga calls Kanyehamba. May he so rest in eternity. Mulenga has since passed on. He calls Kanyehamba and said, my brother, I'm sorry I took you down in the valley and I abandoned you there. That marked the end of the story. So Mulenga threw the dice. It became 3 dissenting, 4 upward. And that's how we decided. But the story we are telling you about Kanyehamba, the kind of stance he took, the kind of position he took, the assertiveness. You know, he writes in defense of the abrasive character, the way he told off Odoki that please, I will not be bulldozed. And the fact that he followed his conscience. Initially he hadn't been convinced, but he wasn't just influenced by his colleague, but he took a cautious decision after reading the evidence and taking the appropriate decision. That is the man we celebrate. The illustrious career he has lived all of his life up to the last minute. On the progress, if at all there is any, and the actions we are taking. You recall the last time we appeared before court, they had tried to pursue an application to open Dr. Besigye and Besigye's phones so that they could access the data on those gadgets. And after a spirited fight that we took up, finally our worship Nantege had to dismiss the application because obviously she had no jurisdiction after meeting with Dr. Besigye. As we speak today, Dr. Besigye and Besigye have clocked 240 days on remand. 240 days. The Constitution is quite clear and very, very instructive. In Article 23, once you have clocked 280 days, rather 180 days, you're entitled to mandatory pay. You don't need to repeat this time again. Once one has been on remand for a period of 180 days, you're entitled to mandatory pay. But there have been machinations and maneuvers within the justice system that have thwarted all these processes of getting paid. First of all, we take exception to those maneuvers, those machinations, the manipulations that have been going on in the criminal justice system to deny Dr. Besigye bail and obeyed it. Very, very unfortunate and regrettable. Secondly, we filed applications for bail. My brother, the Honorable Semuju, has alluded to one which was before Comfort Kenya, which was dismissed without any justifiable reason. After the judge being convinced that actually Dr. Besigye and Besigye have satisfied all the conditions and requirements for grant of bail. But that notwithstanding, she denied their right, which is guaranteed under the Constitution. But now what is happening? We subsequently filed 2 applications. The head of the criminal division of the High Court, Justice Waguma, allocated these files to Justice Emmanuel. That's not true. The head of the criminal division of the High Court is called David Matovu. Sorry. It's called David Matovu. Allocated the 2 files to Justice Emmanuel. Now, I had the conversation and discussion with him on these matters and put it squarely to him that please, you have a duty to fix these matters, have them heard, and you decide them one way or the other. Can you imagine the arrogance he has exhibited? He told us in our face, in no uncertain terms, that he's not going to fix those applications. He has totally refused. He said, do whatever you want. I am not fixing these applications. Then we asked him, please, can you return the files to the person who assigned them to you, the head of the division, Justice Matovu? Again, he refused. He's holding onto the files, but he's not ready to fix them for hearing. We had to write a complaint to the head of the division and copied in the principal judge. Up to now, we have not been favored with a response from the principal judge or even the head of the division. They have all kept quiet. We have all these communications. There is a trail of communications which we will share with you. Then you wonder what they are up to. That is the status of the bail applications. Now, regarding the main, Dr. Besigye and Besigye, we are committed to High Court for trial. And what happens, once you are committed, the file from the Chief Magistrate in Nakawa was supposed to be transmitted to ICB, because that's where the trial is going to be conducted from, to the International Crimes Division of the High Court. Up to now, our worship Nante is still holding on to the file. It is still in Nakawa. Up to now, it has not been forwarded to High Court, to the ICB. You asked Nante, you did your work. You were supposed to handle pre-trial processes. You are supposed to process the issues to do with the investigations within 6 months. That was done. You tried to extend your time. We frustrated it. We thwarted it. We blocked it. Legally, we blocked it. Now, what is it that you are doing with the file of Dr. Besigye and Besigye after committing them to High Court for trial? She cannot answer that question. So these are the frustrations we are expressing to you, which we have requested. We wanted the matter to be fixed for hearing at ICB. We first the registrar at the ICB. That can't you fix it in the session to have the matter heard? Said, but the file is not here with me. Then we asked the registrar of the ICB, can you write to the magistrate to bring it? He said, but we are not notified that they have finished the trial, the pre-trial processes. They have no record whatsoever that Dr. Besigye and Besigye have since been committed to High Court for trial. That's where we are now. Now, what do we intend to do? We are agreed. We are going to assemble here in a week's time. All of us at Katonga here, we are going to let you know that we are going to the principal judge. Yes, we are going to assemble here. We are giving them only 1 week, within which to process all these issues and to this kind of ping pong to come to an end. We want this ping pong to come to an end within 1 week, or else we storm the office of the chambers of the chief, the principal judge, and cause these matters to be fixed for hearing. The Constitution commands that one is entitled to speedy and fair trial. You can't hold the people incommunicado without trial. Totally unacceptable. So we are saying, please, if they are not ready to process this matter, to have them fixed for hearing, let them release Dr. Kizza Besigye unconditionally. So we are going to face off with the principal judge over this matter. If we don't get a remedy, then we shall square up with the Chief Justice, and we are not going to leave any stone unturned until we have gotten justice for our people, Dr. Besigye and Robert Twale, and all other political prisoners. That is the position. Related to that, you know, the legal team is headed by Senior Counsel Baka Karua. So even Nairobi, we assembled up a legal team, a very, very strong, formidable legal team, which is pursuing these matters that side. And in the course of today, the team in Nairobi is filing a case against the government of Kenya for the abduction of Dr. Kizza Besigye from within their territory. This is not Iara. This is High Court Kenya. Rather, yes, High Court of Kenya in Nairobi. They have their Constitution and Human Rights Division. That's where the matter is being filed today by our legal team in Nairobi. Today, we have finalized the necessary paperwork. They came here, wrote the affidavits. They were signed by Dr. Besigye and Obedi Twale from Ruzira. The law requires that if you cross-border whatever litigation, you get all the papers this side be notarized. We got a notary public who went to Ruzira, notarized these documents, and then we sent them back to Nairobi. Now the team has finalized the necessary paperwork, and the filing is today. And these are the offices that have been dragged to court. The Cabinet Secretary, Ministry of Foreign Affairs, the first respondent. The second one is the Cabinet Secretary, Ministry of Defense. The third one, Cabinet Secretary, Ministry of Interior and the National Administration. The fourth one is the Inspector General of Police of Kenya. The Director General of the Directorate of Immigration Services. And the Honorable Attorney General as the sixth respondent. And then the seventh one, the officer in charge, Maraba Border Post. The reason, one, abduction and killing up of Dr. Kizza Besigye, not taking them through the due process there before deporting them, because they needed to be declared them as fugitives, criminal fugitives in Kenya, and they had to seek for court orders within the judicial system of Kenya for an order of transfer back to Uganda. That is what is provided for in the Extradition Act of Kenya and the Extradition Act of Uganda. They never followed the process, the due process provided for in the Extradition Act. 2. Meanwhile, Mwami Museveni ali mu kibuga abinuka. Oba abinuka simanyi oba asobola kumyaka gyonna. Naye ali mu kibuga yeetaaga. Tumutegeeza ebyo byonna abikola. Naye ewiiki ye kekwe naffe tugenda kusituka mu kibuga. Era tetumusuubira anti yaguddewo oluki nti aye ekibuga tusobola okugenda kati kampeni kati fulubuloni kampeni baasi naffe katumulinda amalirize ebibye naffe twetale mu kibuga mugenda kutuwulira for God and Michael.